right, so we have Danielle here from Business Ease, and I'm so excited to have you joining us. She and her partner have created this incredible business where they are helping small business owners with the legal side of creating their business, and it's something that's definitely needed. And I'm so excited to have you here, Danielle. And I just wanted you to tell me a little bit about your business and how you got started before we jump into asking some virtual assistant questions specifically.
Awesome. Well, thank you so much. I'm really excited to be here. Um, I am. I'm a lawyer, and so I used to be in private practice for quite a while, and I wasn't happy. I think this is a common refrain that you hear from lawyers where they weren't thrilled in private practice. And I left to become chief marketing officer and general counsel of an influencer network. So we worked with a lot of health and fitness bloggers in that role. And while I was there had been this sort of nagging idea that there was this need for folks who had small, preferably online businesses where they didn't have access to the kind of legal advice that they needed. And LegalZoom is obviously one option, but when they would go to LegalZoom, first of all, if you don't know what you're looking for, it's really overwhelming. And second, it wasn't specific enough. The contracts would be sort of what they needed, but then they might also still need to hire an attorney to go over them. So my partner and I had both been sitting on the same idea without knowing one another. And then we met and we're talking about it. We were like, let's get business married. And it happened in Vegas, so it was an easy, quickie wedding. And
Awesome.
so we got business married, and then that's how Business Ease was born. And our goal is truly, we always say, let us handle the boring office stuff so that you can concentrate on your passions. We love doing contracts. We love helping people negotiate and do pricing and things like that. So it all works out. Those are our passions, and we know that they are not most people's.
Right.
So we have that. And then for people who need a more traditional law firm, or if it's something specific that they need, we also have a separate law firm called #Legal that also focuses on small online business owners.
Awesome. Well, what an incredible business. I mean, that's definitely something that's unique and that is much needed. So it's really exciting
Thank
to
you
see, everything that you guys have created. So congrats on that.
so much.
Awesome. So I basically reached out to my community and asked for a few different questions that apply to virtual assistants specifically. So as a virtual assistant, they are normally contractors, independent contractors, freelancers, and so I know that sometimes the rules can be a little bit different. And so as far as just coming up with some specific questions that virtual assistants have for running the legal side of their business and making sure that they're covered, those are a few questions that I have for you. So I guess we'll just jump in.
Absolutely.
I guess if you could narrow down just to one thing specifically, like, hey, if you do this one thing right to make sure that you're legally covered as a virtual assistant, what would that one thing be?
Can you guess? Can you guess what I'm going to say?
Is it a contract?
Yeah. Get it in writing.
Yeah.
That to me is the most important aspect, because if you don't know what's expected from the people who are hiring you, and they don't know what to expect from you, chaos can ensue.
Yeah.
You won't know how you're getting paid, when you're getting paid. And it's important to have those conversations right at the onset, because not only does the contract protect you, it protects your client. And everybody's rights are set out in the contract, and there shouldn't be any questions. Now, there's always going to be questions about, do I need to do X, Y, or Z? But in my mind, virtual assistant is a very broad category. And I know that's something that you talk about. You could have a VA who is working with you on scheduling and responding to emails, but you could also have a VA who's working with you on content creation, like creating images for your website or your blog posts. And you need to be really specific about what you're doing so that you don't run into issues where your client thinks you're handling something, but you've never really addressed it, so you weren't sure about it. This makes sure that everybody knows what's going on for each party.
Right. That's interesting. As far as including your services specifically in your contract, which I know, the contract that we've put together, it has a place for you to list out your services. Over time, if your services kind of change with your client, is should you update your contract? How does that process work?
Depending on the contract, I'm going to refer back to the one that we created
Right.
for your VA toolkit because I think that just makes it a little easier because most people will have access to that. So within that contract, you've got all of your legal rights set out as the contract and the agreement itself. And what we've done is set out the scope of work as an exhibit. It's in Exhibit A. Within the contract at the very beginning, we specifically state that additional exhibits can be included or referenced after the fact. So what I recommend is if your scope has changed substantially from what's originally listed in that exhibit, add Exhibit B and say updated scope of services, updated deliverables for that client. You can always get it back and forth in email saying, just to confirm, I will now be covering X, Y, and Z for you. I always recommend say, I'm going to put this into the exhibit and just attach it so we both have it so that there's no questions concerned, especially if there's new things like due dates or things that you have to turn around in a specific amount of time. Get it put into writing just for everybody's safety.
Yeah. What would you say with the consequence? I know I'm going off script a little, some of the questions I didn't email you before, but what would you say? I'm just, things that I know really are probably crossing the mind of people. What would be the consequence if someone doesn't have that contract in place ahead of time? If they think, maybe that's something I don't really need.
I hear this a lot. And usually what tends to happen is the number one question I get is, somebody didn't pay me and now I don't know what to do. First question I ask, what does your contract say? And if they aren't sure, then we kind of you have to cobble a lot of things together, whether it's from emails or trying to get things back out of the phone conversations. I think that it just avoids a lot of questions and potential liability.
Right.
Because you never want to get into a situation where you don't know what your rights are and potentially violate something that the client thinks is their right. No one wants to end up in court.
Right.
Court costs a lot of money. A lot of times for a really easy, simple, quick litigation, you could still be talking about $10,000 or more to deal with a lawsuit. And if you're dealing with somebody for online businesses, you could be dealing with somebody who's filing in a state where you don't live. So you're then trying to deal with an attorney who's in a different state, and it can just be chaos. My goal there is always try to avoid that and make sure you've got everything covered so you don't have to deal with that situation.
Right.
My key for this is I always say be proactive instead of reactive.
Yeah.
It's best to get it set straight right at the start rather than deal with it after the fact.
Now, I guess that brings me to the question because this is actually something that I found myself in once as a virtual assistant, and I know that a few people have. What if, even if you have the contract in place, what if you do come up with a client who just won't pay for some reason? What's your advice to virtual assistants who are in that scenario?
My first piece of advice is check your contract. You need to make sure that you know what your contract says. And what I've seen happen in the past when people aren't paid is that there is a miscommunication between the client and the contractor as to when they're going to be paid. There are some folks out there in some agencies, some different companies who pay net 90. And I know most of us are thinking, that sounds like a really long time. And I think it is. So if you're thinking you're going to be paid due on receipt for your invoice and they're thinking you're going to be paid net 90, that could be part of the problem where they're not sure. Now, your contract can also set forth that if they don't pay, you can terminate the contract. So that's really important that you know you can breach it and terminate the contract without breaching it. So because they have then breached. So that protects you so that you aren't then going to be in trouble for not continuing to work when there's an issue. Now, the other piece to that is once you've checked your contract and you know, yes, they are for sure late, I usually suggest a progression of steps. First, what is the normal way that you communicate with that client? Reach out to them and make it a little bit more official.
Yeah.
Say, not just part of your normal correspondence, specifically say, I sent you this invoice. It was due on this date. We are now however far past due. I need to know the status of my payment. They respond. If they don't respond and you're handling it via email, I then recommend making the phone call. I know a lot of times when we work online, we try to avoid the phone a little bit. Don't. The key there is you never know if you're working with a company as opposed to one individual, you never know if someone is on vacation, if they had an emergency and they're just out of town, or maybe they left and the new person is kind of still trying to figure out what's going on.
Right.
So always make a call, make sure that that person is still there, and try to figure out what's happening.
Yeah.
Now, if you know they're there and they're still ignoring you, what I recommend is the certified letter approach. And that is send a letter. Basically, it's a collections letter, so there's certain rules that you have to follow there. But what you can say is, I have reached out to you on X, Y, and Z dates. You know, I usually try to show that you've tried to contact them 2 or 3 times before you went this way. And then say, you had an invoice that's due, you are now past due, and if I do not receive payment by whatever date, give them a date certain for that letter, I will have to take the following action. Now, because it's a collection letter, what I want to just sort of mention is you don't want to threaten an action that you may not take. So don't tell them, I'm going to sue you if you don't have any intention of taking them to court, because that can then violate certain collection practices acts of the FDCPA. So you can then tell them, I will be terminating our contract. I will be submitting this to a collection agency. If you do plan to take them to small claims, you can say that you will, but just don't threaten any type of action that you don't intend to take.
Okay.
So that's usually the kind of progression that I tell people to go into. Mm-hmm. And you'd be surprised at how many people will ignore an email or a phone call that are something like, certified mail.
Right.
And then they're finally getting it. So that's why one thing that's important is at the time you do the contract, make sure you get the physical address. I know when we conduct business online, we may not get that. Make sure you have an official address. You can show that something was delivered.
Right. Awesome. Okay, that's really helpful information. It's a scenario that nobody wants to find themselves in, but it does happen on occasion. We all know, and so and I like what you said too, just at the beginning of the reaching out to them a few different times, making sure that you record that. You know, you take note of the different times you reach out to them for 2 reasons: to show that, you know, hey, I've reached out to you on these separate occasions, but also just for that benefit of the doubt factor, just because we all know that things do happen.
I would also add, keep in mind what kind of company you're reaching out to. Mm-hmm. If it's a large company that has a separate AR department, make sure you're giving people adequate time to respond to you. I think what tends to happen is in our online world, we get used to these super fast responses where everybody, and 3 days, it's like, they're ignoring me. Make sure you give people enough time to actually try to track down what happened to the check, what happened to this, what happened to that. So give them a week or so before you follow up. Right. And just, again, you don't want to make it too aggressive. I've seen some people who were like, email one day, okay, you didn't respond, I'm going to update and escalate, and then you didn't respond, now my certified letter's going out, and the person's like, I was just checking with AR. So just give them a little bit of time.
That's good. That's good to note. All right. Let's see. When virtual assistants are first starting out, I know that one of the big questions is whether they should be a sole proprietor or if they should form an LLC. Do you have any advice to that question?
I do. Whenever you are starting a business, I'm always going to recommend that you set up the LLC. Okay. It's not a huge investment depending on where you live. It's typically under $1,000, and it gives you protection from any type of liability. If you're a sole proprietor, that means that it is you, the individual, are the business. Right. So if there is an issue and you are sued, they can come after you and your stuff. Mm-hmm. And that means your house, any of your possessions, all of your personal assets are then kind of combined with the business. When you have an LLC, because it is a separate legal entity, you are then, and there's a lot of stuff in the statutes, it depends on where you live, but they're generally the same, where you're protected from the liability for that company. You are separate entities. They can't come after your house. It just limits a lot of your potential exposure. So it is for sure something that I really advise, because you're in a situation, depending upon the kind of work that you're doing for somebody, let's say you are a VA that specializes in infusion soft funnels. I think that's probably a more specific area that maybe not everybody on this seeing this is going to deal with, but there could be some pretty serious ramifications if there was a big error there. Right. That could really start to impact somebody's bottom line. And you want to make sure that you're protected in case something like that happens.
Right. That's good to know. And so you recommend just right off the bat as you're forming your business, just go ahead and do that?
Yeah, if you're a business that's planning to make money, that you're budgeting into this, if it's only going to be a little bit on the side, or you're maybe handling some emails, it may be something that you want to weigh as you bring money into the business.
Mm-hmm.
But I think it's much easier to do it from the start, because then you can keep your finances completely separate. You
Right.
can keep everything separate. So there's no question as to whether it is you individually or the entity is liable.
Right. Awesome. Great advice. Thank you. Let's see here. I had a few people ask me the question about becoming insured. Do you have any tips on whether a virtual assistant um, should be insured or not?
I always think insurance is a good idea. I'm not an insurance broker, so I can't speak specifically to the types of insurance that you may need or the thresholds that I would recommend. But I do think that you can get a GL, or general liability policy,
Mm-hmm.
for not a ton of money each year. I think that depending upon they base it upon your profits.
Right.
So you're just getting started and your profits are still relatively low. You can often get a general liability policy for under $50 a month. So I do think it's a really good option to have, because, again, if something goes wrong and your business doesn't have the money to cover the judgment, that's where the insurance is going to come into play. And I think that it's just a very good safety net to have.
Right. Okay. Thank you.
Mm-hmm.
Okay. I've had a few people ask me this before, where they had a client who wanted them, like the client had their own contract. So in that case, should you sign your client's contract? Should you only have them sign your own? Should you sign both contracts? How do you navigate that
You should
situation?
only sign one contract, because most contracts are going to have a clause that says this is the controlling document. So
Okay.
you can't have two that are controlling. What you want to make sure now, first, one thing that I've seen this online a few times, where they're like, no, they have to sign my contract, and they don't. What they need to sign is a contract that has the right terms.
Okay.
So that's really the most important aspect, is make sure that if you have certain terms in your contract that are extremely important to you, they better be in that other person's contract too. Do not be afraid to redline and revise that contract and send it back to them with changes. It's a negotiation. And things that always come up are things like they may have different payment terms. You want to make sure that the payment terms are accurate, so that you know what to put on your invoices to that client.
Right.
Make sure that you have confidentiality in there, that you have all of the terms that are important to you from your contract. A lot of times things will be similar.
Mm-hmm.
Most base contracts for independent contractors will have a lot of the same stuff. So just make sure that your contract with them has the things that are the most important to you, and that essentially it matches in the end.
Okay. Now, when it comes to revising contracts, if somebody, so say I'm a virtual assistant and I send my contract to a client and they want to do some revisions to it, they want to negotiate the terms. Is there anything that you say, just, make sure that you don't negotiate this, or is there anything that's like hard and fast, like make sure this is in your contract?
I think that the most important pieces that you want to see in every contract are, make sure those deliverables are spelled out. It shouldn't just say, I'm going to be your VA. Make sure it's specific as to what you will be doing for that client. Make sure that you know what counts as confidential information. In the VA industry, confidentiality is paramount,
Right.
and you need to know what is covered if you are allowed to even reference the fact that they are your client. So make sure that you know what you can and cannot talk about. I would say the intellectual property piece is really important. If it's something where you're going to be creating copy, creating images, anything along those lines, make sure that's in there. And then most important always is payment terms. Make sure that you are at least in agreement with the payment terms. We all would prefer to have it due on receipt, as soon as it goes out, on the first day of the month following when the services were performed. And if they want net 30, it's not a bad thing to take that, as long as you know for your business. I don't think that's often a make or break type of thing, if it makes sense for you. But that's a decision that only you can make, depending upon, is it going to completely mess up your bookkeeping? Is it going to be, how does it impact your workflow, and is it going to be an issue? So in terms of things that I would always say to reject, within the contracts, you're going to see an indemnity clause. Lawsuits are filed every day over indemnity, all the time. And essentially what it means is if there's a lawsuit that comes and both parties are involved, they can then say, you're responsible for dealing with the defense of that lawsuit. You're holding them harmless from everything that went wrong. Make sure that that is relatively narrow. In the contracts that we've created, it is pretty narrow to say they can come to you if it's because you were negligent. So, or if it was because you infringed on someone's intellectual property rights and you shouldn't have. You should have, gotten licenses, whatever the case might be. If they come to you and say anything that happens that you may have had your hands in, you're responsible for, and it's very broad, that I would shy away from and try to get that revised a bit. And then make sure that they also have indemnity that protects you. So when you see a one-sided contract, oftentimes that would say, no, I'm just going to protect myself and I'm not offering you any protection. So what I want is to make sure that you are also protected in there, and that the other thing that I would say make sure you have included is a termination provision, so that if something is going very bad, that you can get out of that contract and ask for written notice, because just like they can get out of the contract, just like you can, so can they.
Right.
So you want to make sure that you know how many days notice they have to give you, and that it be in writing. And usually you can say that in writing is through email.
Right.
So those are the kind of things that I say are, make sure you know what you're signing and that those are included. So even if they've sent you revisions, if you know that those areas are covered, you can be comfortable with what you're accepting.
Right. And I feel like that's probably not going to be the case most times, that people would, it's probably going to be like, oh, maybe let's add these services as well, or let's change this a little bit with the.
Usually you're right.
Yeah.
And if you're dealing with a really big company, maybe you'll see that level, like if they've got in-house, or if you're working with an attorney, then we like to revise a contract. Sorry. But if it's a smaller company, usually what you're going to see revisions to a lot of times are the payments.
Yeah.
And the ownership of the work product. Like I said, typically it's going to be your client who owns it. And then you may see some revisions to confidentiality, just to include, they may say, all of my business systems, my process is covered within that. Those types of changes really are not a concern.
Yeah. Doesn't have to be a scary thing, right?
It really doesn't. Whenever I say,
when you start to hear about
I even said this to people. Don't be afraid. Most of the time, people aren't going to change that. I promise. It's usually not a big deal.
Yeah. I think, no, you were making it sound too scary. I mean, it's good though. It's good to know like the reality side of it, that like, hey, this is why having a contract is important. This is why you need to have yourself covered. This is why, you need to have these different things, but just know that like once you have that in place, then you're good.
Right.
And that's why you do it up front.
Like the doom and gloom person who's like, no, you got to do it. But then honestly, as soon as it's in place, usually you can, what is that old rotisserie chicken infomercial? You can set it and forget it. That one. Yeah. I think I'm dating myself by referencing that. But yeah, you can usually just kind of go through, and unless your deliverables change pretty drastically, then that's the only time you would need to make an update.
Right. Awesome. Thank you. All right. Do you have any tips specifically about, once a virtual assistant reaches a certain level where they can't take on any more work themselves, oftentimes they'll bring on subcontractors, so people to work underneath them to do some work, and then they'll send that on to their client. Do you have any tips for virtual assistants who want to bring on subcontractors for their business?
Absolutely. You already know tip number 1, get it in writing. So what you want to make sure, first you want to check your client contract and make sure that you are not prohibited from using subcontractors. The one that we have created, it allows you to use subcontractors. So please don't worry about that if you're using our form. But if you're using a form from the client, just double check and make sure that it's okay. Then the pieces that you want to make sure of are that, number 1, they know there's no ownership, so that intellectual property piece again, and that you know what you are paying them. Make sure that you have something in there, which we have included, that is specific, that the work has to be up to your quality standards.
Right.
That you basically have to accept it, otherwise they need to redo it at no charge to you. then make sure that your payments are clear. One aspect that's going to be extremely important is that your confidentiality provision with your subcontractor needs to match your own confidentiality provision with your client. And it should specifically say, you're going to get information about contractors' clients, and that has to stay confidential.
Right.
You can't go after those clients. We've got non-solicitation and non-circumvention agreements in there. So what that means is you don't want your subcontractor trying to go around your business and say, hey, I can do this for you cheaper than what they're doing. You never want that to happen. Make sure it's included. You don't want them to then say, or then go after them and say, hey, I used to work for Abby. Now I want you to just hire me directly. Let's cut out the middleman. No, you need to make sure that that is also included. So we've put those into the template contract. But when you're working with a subcontractor, definitely make sure that those pieces are there so that you don't have to worry about them approaching your clients.
Right. Definitely. Good. This is all such good information. Okay, I have just a few more, one or two. What does it mean? I had someone ask me this in my group the other day. What does it mean if my client wants me to sign an NDA? Should I do it?
An NDA is a non-disclosure agreement. And usually what an NDA is, a lot of times you may get an NDA prior to getting your official contract to work for them. And that means they want to talk to you during your initial discussions about something confidential. I'd have no issues most of the time signing an NDA. And essentially what that means is there is a duty of confidentiality to the information that you are receiving from that person. What I want you to look for if you get an NDA from a client, make sure that's all that's in there. I've seen some NDAs that are a little bit slippery, and I've seen some that will slide in a non-compete clause or a non-solicit, and it depends on who your client is. If you do work with, let's say you work with a PR agency who has their own set of clients, right. I've seen them come in there where they don't want you to then go after their clients, which is fine, but the thing is that's not necessarily part of a confidentiality agreement. It's just something I want you to be aware of. Just look for those things. But if it is primarily something where they're saying, this is the information, this information counts as confidential, it cannot be disclosed unless it's the following circumstances. And usually it will say, information is not confidential if it eventually becomes public and you're not involved in it, those types of things. And they will usually last. Don't be surprised if you see it say that it's going to last for 10 years. That is often the case. Because I know a lot of people are like, 10 years, that's a really long contract. But when it comes to confidentiality agreements, that's often the case.
Right. What if you do have the circumstance where, talking about the non-competition, what if you have a client who maybe she's a health coach and she says, I don't want you to work with any other health coaches? Do you have any advice to give if a client's asking that?
What is it worth to you? Usually what I tell people, when you are presented with a non-compete clause, consider, number one, do you work with a lot of health coaches? Because if you do, that could impact your existing business. Mm-hmm. How much income are you going to lose because you are not able to take on additional clients within a certain field? And adjust your pricing accordingly. And let the person know, this level of exclusivity that you are requesting from me comes at a price. And that the other piece is you can also try to narrow the scope of what would be covered in that non-compete or the exclusivity provision. And you can say, okay, I still work with other health coaches. How about I do not work with other health coaches? Like, let's say this person is not online based and they're more local to a specific county somewhere. So then you can say, I will not work with other health coaches who are located, within a 50-mile radius of where you are. Or if they are a health coach who deals specifically with postpartum women, for example, you can say, I will not work with another health coach who focuses specifically on this group of clients. And the more you can narrow it, the better it is, because it can make it, if it's too overbroad, health coach could really encompass a lot of stuff. So, and you need to make sure that you understand exactly who falls in that definition if you are being excluded or prevented from working with someone, because they may say to you, you may think, okay, health coach, somebody who is very specifically talking about health and fitness. But then you may get someone who is talking more about like meditation and that type of life coaching, something along those lines. In a holistic sense, yes, that's still a part of one's health. So does that then fall under the same guide, even though that person may talk about, nutrition. So you want to make sure that you know exactly what they mean, and then make sure that it is worth it to you to sign that provision.
Right. Very good. That's incredibly helpful. Any other tips just in general, just for a virtual assistant just starting out, or maybe who's been running their business a while? Just any last legal advice that you would want to give?
I think that the biggest thing is just make sure you understand what your contracts say. If you've got questions on it, it is always better to pay an attorney to do a quick review or just to ask a few questions than it is to not know and then have a problem. Right. And I've seen that happen before. And it's kind of like what you said with the exclusivity provisions. Make sure you know exactly what it says, because if you don't know what it says, then it's kind of hard to run your business, really. Right. So just make sure that you know exactly what's covered. That's the contract side. My other piece of advice is, if you set up an LLC, I want you to make sure that you have funded that LLC correctly. And funding can sound like a bit of a daunting word, I know. What I mean there is, when it comes to an LLC, the reason that you are protected from liability is because it is the business that is taking control of everything. If you are still having people pay you directly instead of your LLC, then you're doing a lot of commingling. You don't want to do that, because then you can still be held personally liable. What I recommend you do is, after you get your LLC set up, get an EIN from the IRS. Right. It's not a requirement for when you file your taxes, but I personally think it makes it a lot easier for you to separate your banking and separate all of just everything.
Right.
And then make sure you've got a separate bank account and that your clients pay you through that account, and then you do your draws from that operating account.
Right.
And if you've got questions on how you should be taxed, for sure, talk to an accountant who deals with small businesses, because there are times when it's going to be beneficial for you to be taxed as an LLC, which is taxed as a sole proprietor or partnership, or it may be beneficial for you to be taxed as an S Corp. So talk to a CPA, and again, it doesn't have to be a really lengthy conversation, but just so you know that you're handling your money the right way, so that you are getting the full protection of that business entity.
Right. Wonderful. That's very good information.
And I hope it's not too scary, especially if somebody's just starting their business. We don't want to frighten you. We just want to make sure that you are protected from the start.
No, it's really, this is so good. I wish I knew all of this when I was first starting out, because I still have clients who that I still never got payment from, and I didn't get their address from the beginning. There's things I did wrong in the beginning of my business that, looking back, I'm like, oh, I could have covered myself so much better at the very beginning. But that's why you
created your boot camp, so that you can teach everybody how you got successful.
Exactly.
But how to avoid any missteps that you may feel you made along the way.
Exactly. So this is so incredibly helpful. Thank you so much. If any virtual assistants do have questions about their contracts, about any of their agreements or negotiations, how can they reach out to you? Is that something that they can do?
Absolutely. If you have questions about the template that we created for you, you can reach out to Danielle at businessease.com. That's businessese.com. If you need to retain a lawyer if you don't want to set up your LLC yourself, you need help with that, or if you need someone to personally review something, you can reach out to me at Danielle at #legal.com.
Wonderful. All right. Thank you so much. I really appreciate the time that you've taken to chat with us.
Thanks so much.
All right.
Bye.
Bye.